I bought the house because of the driveway. That sounds like an odd thing to say, but when you own 3 vehicles, a daily driver, a weekend sports car, and a pickup truck that earns its keep hauling materials for home projects, driveway space isn't a minor consideration. It's a deal breaker. The house I found in an upscale HOA neighborhood had a wide, well-paved driveway with room for all 3, a clean garage, and not a single rule in the HOA handbook prohibiting multiple vehicles on private property. I checked before I made the offer. All 3 cars were legally registered, fully insured, and would be parked entirely on my own property. I had done my homework. I moved in confident that I was following every rule that existed. What I hadn't accounted for was Linda Harper, who had rules of her own. Linda was the HOA president, and she lived directly across the street with a clear sight line to my driveway. I noticed her staring a few days after I moved in. Not the casual glance of a curious neighbor, but the focused, evaluating look of someone forming a position. A few days after that, she crossed the street while I was washing my sedan and announced, without introducing herself, that homeowners weren't supposed to have that many cars. I asked her to show me the rule. She handed me a violation notice instead. That night, I read the HOA handbook cover to cover. Every page. The regulations addressed abandoned vehicles, commercial trucks, boats parked on the street, and various other specific situations. What they did not contain, anywhere in any section, was a limit on how many registered, insured, privately owned vehicles a homeowner could park in their own driveway. I highlighted the relevant sections, wrote a clear response explaining this, and submitted it to the HOA office. A week later, a second violation notice arrived, more aggressive in tone than the first, with additional language about community appearance and neighborhood standards. It cited no specific rule because no specific rule existed. This was no longer a misunderstanding. Linda simply didn't like my cars, had decided they needed to go, and was apparently willing to generate paperwork indefinitely until I complied. The matter went to a board meeting. Linda spent several minutes presenting her case about visual impact and community aesthetics. When my turn came, I put copies of the actual HOA handbook on the table in front of every board member and pointed to the sections that govern vehicle parking. Multiple members read the relevant pages in real time. The meeting ended without any enforcement action against me because there was no rule to enforce. Linda left that meeting looking like someone who had just been told no for the first time in a very long time. I assumed it was over. I was spectacularly wrong. 2 mornings later, I walked outside and stopped dead at the edge of my front steps. 2 of my vehicles were gone. The driveway spaces where they'd been parked the night before were empty asphalt. My first thought was theft. My second thought was Linda. I went directly to my security camera system and pulled the overnight footage. What I watched made my jaw tighten in a very specific way. In the early hours of the morning, 2 tow trucks had entered the neighborhood. They had removed both vehicles from my private driveway with the methodical efficiency of a planned operation. Standing nearby, watching, supervising, ensuring the job was done correctly, was Linda Harper, HOA president, in a jacket in the cold, at 2 a.m, personally overseeing the removal of cars she had no legal authority to touch. I called the towing company when their office opened. After working through several conversations and escalating to someone willing to actually answer questions, I confirmed what the footage already showed. The removal had been requested through HOA channels and personally authorized by Linda. My legally registered, properly insured, correctly parked vehicles had been towed from my private property on the instruction of a woman who had already been told by her own board that she had no rule to enforce. I stopped treating this as a neighborhood dispute at that exact moment. I spent the rest of that day building a file. Security footage of the removal. Every violation notice, dated and preserved. Copies of the HOA handbook with the relevant sections marked. Documentation of the board meeting outcome. Records from the towing company establishing who had authorized the removal. When the file was complete, I called an attorney. He reviewed the materials for less than 20 minutes before looking up with the expression of a professional who has just seen someone make a serious and entirely avoidable mistake. The HOA regulations didn't support the tow. More importantly, Multiple required procedural steps have been bypassed entirely before the vehicles were removed. Steps that exist specifically to protect homeowners from exactly this kind of unilateral enforcement action. The legal exposure for Linda personally and for the HOA as an organization was significant and immediate. Formal legal correspondence went out to 3 parties simultaneously: the HOA board, the towing company, and Linda directly. The effect was rapid and clarifying. The confidence Linda had projected for weeks, the violation notices, the board speeches about community aesthetics, the 2 a.m. supervision of an unauthorized tow evaporated. Word reached me through the community that she looked genuinely shaken when she understood that the situation had become a legal matter with her name specifically attached to it. The board called an emergency meeting. As members worked through the evidence, the picture that assembled itself was not flattering to their president. Linda had acted without board approval. She had misrepresented HOA authority while pursuing what was, at its core, a personal aesthetic objection to a neighbor's legally parked cars. And in doing so, she had exposed the entire association to liability that the board members themselves were now going to have to manage. Linda attempted to frame her actions as community protection. The board was more focused on the legal reality than the framing. When an HOA president tows cars from private property without authorization and without an enforceable rule to stand on, the conversation shifts very quickly from community standards to organizational liability. Both vehicles were returned to my driveway within days. The towing company waived every fee, a decision that reflected their own understanding of how badly the authorization chain had failed. I documented the condition of both vehicles thoroughly upon return. The HOA then formally withdrew every violation notice that had been issued against me across the entire dispute. A written apology followed, acknowledging that the rules had been misapplied and the enforcement actions were improper. It was the kind of letter that organizations produce when their attorneys have explained the alternative. Linda was removed from her position shortly afterward following an internal review. The board's conclusion was straightforward. Her conduct had generated unnecessary conflict, bypassed required procedures, and created serious legal exposure for communities she was supposed to be managing responsibly. After word spread through the neighborhood, several people came by to say things they'd apparently been holding for a while. Multiple neighbors mentioned their own past run-ins with arbitrary enforcement, notices that seemed personal rather than rule-based, complaints that cited no actual regulation. The particular frustration of being told to comply with something that didn't exist in writing. Most of them had simply absorbed the friction and moved on. Watching someone push back, methodically, legally, with a documented file and an attorney, apparently gave a few of them permission to start asking questions they previously swallowed. All 3 vehicles are in my driveway right now. Same spot they've been since the day I moved in, except for the brief period when they were towed in the middle of the night by someone who confused their personal preferences with institutional authority. Here's what I'd tell anyone who finds themselves in something similar. Read the actual rule book before you comply with anything. Not a summary, not a notice. The actual document. If the rule doesn't exist in writing, it doesn't exist. And if someone with a clipboard and a title tells you otherwise, ask them to show you the page. They can't show you a page that isn't there.